One wrong sentence during a traffic stop, and your lawful gun ownership can flip into a felony. I'm talking about exact phrases officers are trained to repeat in court, even when you believe you're being helpful and truthful. Today, I'm unpacking the 5 most dangerous words gun owners tell police that wreck their legal defense. By the end of this clip, you'll know precisely what to utter and what to never utter when an officer asks about your firearm. This isn't hypothetical. Last month in Texas, a concealed carry driver said only 3 words during a routine stop. Those 3 words cost him his carry license, $15,000 in lawyer bills, and 24 months of court fights. He thought he was doing the correct thing. He was dead wrong. Number 1. I didn't realize. When an officer realizes you're armed inside a forbidden zone, maybe a post office lobby, a school lot, or a city building, your first urge is to explain. And the most common reply, I didn't realize that was illegal. Here's the trap. Under the legal rule of ignorance of the law, saying, I didn't realize is not a defense. In fact, it's a confession. You've just told the cop you performed the act you carried inside a restricted place. The only issue left was intent, and you just erased any argument your counsel could shape around that. In 2023, a Louisiana carrier said exactly this when spotted armed in a courthouse garage. The DA used his own sentence against him. Result, Class B misdemeanor, $2,000 fine, forced surrender of his concealed license for 3 years. His attorney later admitted the case might have been tossed if he'd simply stayed mute. Here's what you do instead. If the trooper says you're in violation, volunteer nothing about what you realized or never realized. Your single reply, I'd like to consult counsel before answering questions. That's it. Your lawyer can tackle knowledge and intent later, once they've had time to study the real statute and craft a real defense. But here's the part most owners skip, and the next line is even riskier because it sounds cooperative. Number 2. It's only in my pickup. You're stopped for a busted taillight. The deputy asks whether there are any weapons in the auto. You want to sound cooperative, so you answer, yeah, it's only in my pickup, or it's only in the glove box. That tiny word, only, legally equals an admission of possession and control. In front of a jury, the state will argue you knowingly placed the pistol exactly where you described. If that spot happens to breach a local rule, perhaps you're parked beside a campus. Perhaps you crossed into a state with tougher storage laws. Perhaps your license doesn't cover vehicle carry. You've handed them every element they need. Florida, 2022. A driver told a trooper his handgun was only under the seat. The trooper found it loaded and not in a locked container. Under Florida statute 790.2025, that's unlawful without a carry license in certain contexts. The driver did hold a license, but it had lapsed 2 weeks earlier. His own description of location and accessibility was wielded to prove he had instant access to the weapon, bumping the charge to carrying a concealed firearm without a license, a third-degree felony carrying 5 possible years. Your proper reply. If state law forces you to notify, you declare, I'm informing you I'm a licensed carrier. Period. No address, no details, no elaboration. They'll ask where it is. You answer, I'd rather discuss that once counsel is present. That can feel uncooperative, I get it. Yet cooperation at the roadside does not mean volunteering data that can be weaponized against you downstream. Which brings us to the 3rd sentence, the one that nets more arrests than any other. Number 3. I possess a license. Wait, aren't you supposed to declare that? Not exactly. The hitch isn't announcing your license. The hitch is what normally follows. Picture this. You announce, I possess a license, and the deputy demands to view it. You reach for your billfold, except your license expired last month and you forgot to renew. Or you relocated and didn't notice your old license isn't honored here. Or you're inside a jurisdiction that rejects your specific license class. Now you've given a false statement to an officer. That's a discrete crime in 43 states. In Virginia, it's a Class 1 misdemeanor, up to a year in jail and a $2,500 fine, totally separate from any firearm counts. Tennessee, 2024. A permit holder informed a deputy, I possess a license, during a traffic stop. The deputy ran the database and learned the license was suspended over an unpaid citation from 6 months prior. The driver had zero knowledge of the suspension. The DA charged him with carrying without a license, plus giving a false statement to law enforcement. Final bill, $8,000 in lawyer fees, 40 hours of community labor, and a lifelong entry on every background screen. The safer wording, I'm a licensed carrier, and I'd prefer to confirm my present status through counsel before continuing. If the card is valid, counsel confirms it on the spot, and you're clean. If there's a glitch, an admin error, a late renewal, a reciprocity snag, your attorney handles it before you've uttered a single line the state can quote. Now, the 4th sentence feels protective, like you're asserting your rights, yet it actually hands prosecutors proof of intent. Number 4. It's for safety. An officer questions why you're armed. You want to appear sensible, responsible, law-abiding, so you explain it's for safety, or I carry for self-defense, or you never know what might happen. You've just established motive and intent. If your carry scenario is later ruled illegal, wrong zone, wrong license, wrong state, the DA now owns your own words proving you meant that weapon to be accessible for use. That upgrades the offense in many venues. California maintains some of the tightest firearm statutes in the nation. In 2023, a CCW holder was caught armed inside a posted no-gun zone. When asked why he was armed, he replied, "For safety. There's been crime around here." The prosecutor used that line to contend he deliberately ignored the signage because he valued personal safety above the law. That turned a possible misdemeanor into a count of willfully violating firearms restrictions. He burned 12 grand and 18 months fighting it. Here's how the court reads it. If you state you're carrying for safety, and later they find you in violation, you've confessed you knew the gun was on you and you meant to deploy it if required. Both elements, knowledge and intent, are exactly what the DA needs to pursue stiffer counts. Your reply? When asked why you're armed, "I wish to speak with counsel." That is the sole response that shields you. Don't rationalize, don't elaborate, don't feed them material. But the 5th sentence, this is the one that obliterates more defenses than anything else, and I bet you've considered saying it. Number 5. I wasn't planning to fire it. This is panic reflex. The deputy finds your pistol and you instantly want to calm the scene, so you blurt, "I wasn't planning to fire it," or "I forgot it was even there," or "I never touched it." Congratulations, you've just confessed to unlawful possession while simultaneously wrecking your Fourth Amendment argument. When you say, "I wasn't planning to fire it," you verify you knew the firearm was present. That removes any claim that the piece was planted, that you were unaware it sat in your auto, or that somebody else stashed it there. You've locked yourself into possession. When you claim, "I forgot it was there," you concede negligence. In states with mandatory storage statutes or in cases involving prohibited persons, negligence can be a distinct criminal count. You've gifted the DA a second violation. When you insist, "I never touched it," you invite forensic scrutiny. If your prints are on that pistol, and they will be if you own it, you've now uttered a false statement. That's another charge. Georgia, 2023. A driver was pulled over with a pistol visible on the rear seat. When the trooper walked up, the owner quickly said, "I'm not going to fire it. I forgot it was back there after the range." The trooper cited him for improper storage and transport. The DA used his own admission to prove he knew the gun was inside the car, yet failed to secure it correctly. Under Georgia code, that should have been a $100 ticket. His statement elevated it to a misdemeanor, a $1,000 penalty, and a mandatory safety class. The correct reaction if an officer locates your firearm: silence. Literally, say nothing. If the deputy questions you about it, your line is, "I'm exercising my right to stay silent and I want counsel." That can sound brutal, I realize, yet here's what you must grasp. Anything you volunteer in that instant is designed to protect the officer's safety and to build the prosecution's file. Nothing you offer will improve the stop. It can only worsen it. Let's recap the 5 sentences that can wreck your legal defense when police ask about your gun. 1. I didn't realize. Confesses guilt and erases an ignorance defense. 2. It's only in my pickup. Proves possession and control at a precise spot. 3. I possess a license. Exposes you to false statement counts if anything is off. 4. It's for safety. Establishes intent prosecutors will exploit. 5. I wasn't planning to fire it. Confirms knowledge and demolishes your Fourth Amendment defense. Any single one of those lines could cost you thousands in fees, your carry license, or your liberty outright. When police inquire about your gun, your one safe sentence is, "I'm exercising my right to stay silent and I want counsel." Hit that like and subscribe button and help us reach our amazing 10,000 subscriber milestone. Every single subscriber matters. Your support is what makes this journey possible.